started my exceptions document by saying regulatory checks and balances are integral to Oregon's land use planning system, as are Goal 1 policies and practices, period. I thought that was practically a self-evident statement. However, after being here yesterday and listening in on your conversations with the Citizen Involvement Advisory Committee and some of the follow-up that they were doing, I'm realizing that even more than the way I developed it in this next paragraph, the shift is quite noticeable from LCDC thinking of itself as a regulatory body to LCDC thinking of itself as one of many partners that are trying to collaborate in somehow simplifying land use for Oregon cities, counties, districts, maybe citizens. I may be overstating that, but it's pretty observable to me from my 30-some years of involvement in land use as a citizen activist and 8 years on the Washington County Board of Commissioners, that there is an increased level of cooperation and collaboration among agencies at various levels. Cities and counties, counties and metro, and the state agencies. And I think that's a good thing for the most part, especially if it also includes serious citizen involvement and multiple stakeholder involvement in the beginning stages of the planning process. That was the thinking that went into, I think, the legislation that we're working with now. Things turned out, especially in Washington County, quite differently from what a lot of the stakeholders had anticipated, because the notion of collaboratively, constructively, creatively involving many stakeholders extended only to other government agencies. It did not extend to citizen groups, advocacy groups. You heard in October how badly staffed the coordinating committee was in Washington County, the lack of process through a planning commission or a board vote on the submittal that went to the Corps for as our original ask for urban mineral reserves and so forth. When I heard the announcement about the new legislation requiring now that procedural defects be related to substantial harm done to parties, I think that's interesting, because I think some of the substantial harm that's done to parties when citizen involvement is left out at early stages is done to the people who have to sit here on these boards and commissions through hearings that last for 8 to 12 hours or multiple days, as people hash out things that could very well have been hashed out around tables in informal settings, well facilitated, months and months and months before this. That was not the case in Washington County the first time around, and it remained not the case. I would draw your attention, well, let me step back for just a second. There are really 3 primary areas where I think the faults in Goal 1 procedure, and perhaps beyond Goal 1, occurred in the past year in the research process. First 2 are about Washington County. There was a lack of citizen involvement in the revision of the map. There was lack of notice until a composite leadership development and proposal had been developed to people who were living or owned property inside areas that had been designated rural and were now being considered for undesignated or perhaps urban. And the hardest one to talk about, but the one that is, I think, probably has created the most difficulty for the most people is the fact that following the remand in October of last year, the department, for various reasons that haven't been explained, chose not to issue a final order. You heard from Cornelius the kind of confusion that caused on their part, and the reason why they're back here now instead of having been able to challenge the decision shortly after it was made. It has certainly opened the door to a lot of sort of backroom dealing, which, or what it certainly appears to the casual observer as backroom dealing. Maybe to some of the insiders it's just considered business as usual, I don't know. But as early as November 10th of last year, in a memo from Chair Bryan to some of his senior staff and other board members, he states his goal of replacing Cornelius' 624 acres and Forest Grove's 28 acres remands, quote, acre for acre, as nearly as practicable, and two, type for type. In other words, employment land for employment land, residential land for residential land. Well, apart from the fact that they don't get to be designated one or the other as urban reserves. Acre for acre, as near as practicable, was his goal. It was allowed by you. It was not, we did not give that instruction. And it's evident as we go on through that that remains the overriding goal of the whole revision process. In the same memo, he mentions that there is general agreement that sufficient analysis and public comment is in the record from which amendments can be fairly considered. Neither Metro nor the county feels it is necessary to reopen the analysis process or conduct an extensive outreach and public information effort. Okay? That's not what Goal 1 calls for. Let's see, in a memo from Richard Benner on January 5th, we find him telling Metro senior staff and council, I do not know what Richard Whitman has decided about entry of a remand order. He told me weeks ago that he was mulling the question and would not issue an order without checking with us. I've urged him not to enter an order, but rather to cut down on litigation, wait till we resubmit, and enter a final order after approval. If the department decides not to issue a remand order, that means your two counties have an opportunity to fix anything you think makes the designations vulnerable to the inevitable appeals of LCDC approval order to the Court of Appeals. Okay? Not very encouraging of good citizen involvement. Back to Tom Bryan's memo of November 10th, he says, in reviewing possible areas to which to add urban reserves, we concluded the most logical and possibly defensible would be the rectangular area north of Highway 26, south of West Union and between Jackson School Road on the west and XXXX on the east. Currently there is a 150-acre area designated UR and blah, 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 blah. In November, the chair of the Washington County Board knew what he wanted in his acre for acre exchange, and everything that happened after that was in agreement with his contention also that he wants to make sure, this comes from a memo of November 14th, seems there is strong interest in moving to an IGA before the end of the year. If we can, that's fine, but I want to make sure that we have 3 solid votes on the current and future boards. This is not a process that is open, that is public. This is a process that has been carefully engineered to limit the citizen involvement as much as possible and to get to the end that that a prominent decision maker wants to achieve. I have never before tried to rebut anything that Governor Roberts had to say on any subject, but I want to tell you, I was at that joint meeting, and I did see all the back and forth. I did see all the balancing. It was balancing between what the Metro Board, the Metro Council was looking for, which was a conscionable map that would actually provide good protection for foundation farmland. And the Washington County Board, some of whom would have really liked to protect Helvetia, and Roy Rogers talked about it a lot, and he made one proposal, but in the final analysis, he wouldn't break with the other two members of the board who were determined to stick with Tom Ryan's original goal of matching acreage for acreage. Had nothing to do with factors. All those findings came afterwards. If LCDC is not willing or not able to exercise regulatory authority over the processes that are called for in Goal 1, or the administrative practices that would make it possible for citizens and cities to have a real voice in the outcome of a process whose outcome lasts 50 years, then I wonder what kind of function LCDC really has anymore, and I really hope that we figure out some way of providing some accountability for compliance with rules that you've adopted, and that really, if they are followed, will assure good process and good product in our land use planning program. And we desperately need it because Oregon's at risk. Thank you.
Questions of Linda?
Thank you, Linda.